Okay, I'm going to start with something that is kind of basic, but I just need to know, what exactly is bankruptcy?
That's a great question. Bankruptcy was designed specifically to give people relief from their debt. It was all founded on the premise that people would never create or invent or open businesses or employ people or take chances and risks or really improve our communities if there wasn't sort of a fallback plan. And so bankruptcy was designed to help those people who took those chances and took those risks, and maybe they fell short one time. So it's all designed on the idea that people deserve a second chance. And this is the way to wipe the slate clean and give those people their second chances.
Oh, I love that. I love that. Okay, let me ask you this. There are different kinds of courts. There's federal courts, there's state courts. Where does bankruptcy happen?
Well, federal law governs bankruptcies. So it's sort of a combination of law. That's a really interesting question from a legal standpoint. But there is a federal bankruptcy court that is going to oversee every bankruptcy case that's filed in the state.
Okay.
Missouri is divided into the Eastern and Western District. The District of Kansas has one district. And the state law, the exemption laws, are what apply to your case. So even though it's housed in federal court and it's overseen by the bankruptcy court, you're going to use state court exemptions, and some state law may apply to your case.
Okay. And now, but actually the physical courthouse they would be going to is the federal
You
courthouse.
are not going to go to the Kansas City Municipal Courthouse. You are not going to go to the Jackson County, Missouri Courthouse or the Johnson County, Kansas Courthouse. You're not going there. You're going to the federal courthouse for your state.
Okay.
In Kansas, it's housed over at 5th and State Avenue. It's a big building downtown in KC-Mo. It is a very beautiful building, actually, but it's the federal courthouse. They do see other cases in that courthouse other than bankruptcy. So it's not specifically designed for bankruptcy court. But there's a floor that all the bankruptcy hearings are held on. It's the 6th floor. The 341 meetings for every bankruptcy case that's filed in the state are all held at the courthouse. They aren't necessarily held in a courtroom.
Okay.
I think a lot of that is designed intentionally because there are a lot of individuals who file. They may or may not have had a lot of experience in the legal arena. They've never been to court. So in order to make it a little less intimidating and house enough people, they're held in meeting rooms at the courthouse instead of a courtroom.
I like that. If somebody comes into your office and they are like, I'm getting calls by creditors, I'm freaking out, what things should they bring to you when they are first coming to do a consultation with you? I mean, I'm sure via phone or email you told them what to bring. What are they walking in the door with so that you can begin the determination of, hey, what are we doing here?
Great question. Some of my clients walk into my office with nothing.
Right.
and you really can.
Yeah.
You need some basic information about, what do you own? Who do you owe? And a rough estimate of how much you owe.
Okay.
I'm going to teach you how to run your credit report. I'm going to teach you how to gather the information that I need in order to assess who your creditors are and how much you owe them. But if you know a rough estimate of what you owe, particularly in unsecured debt, so that we can assess if bankruptcy is even appropriate for you.
Right.
The first question I would hope everybody who's contemplating bankruptcy asks when they walk into their lawyer's office, you should always ask, is this appropriate for me?
I love it.
Do I have other options? Because some people do.
Right.
And bankruptcy isn't appropriate for everyone.
Okay. So that's good. This segues into the conversation. The question, what are 3 questions if somebody is contemplating bankruptcy, has an appointment with a lawyer or is talking to lawyers on the phone, what are the 3 questions they should definitely be asking a lawyer?
3 questions that I would ask are, is this appropriate for me?
Right.
If so, what chapter am I eligible to file? And 3, are there any problems with my case?
Okay.
If your lawyer can't tell you those things,
Go find somebody else.
go find somebody else. Because, and to be perfectly honest, your lawyer may not know what chapter is appropriate for you when you walk into their office because of the income qualifying test.
Right.
You know, if you haven't brought 6 months worth of pay stubs and have an hour and $500 to pay them to do your income qualifying test right there, they may not know.
Right.
But they should be able to articulate to you, if you don't qualify for a Chapter 7, here's why.
Right.
And if you don't, here's the plan.
Right.
We're going to file you in a Chapter 13. We're going to do debt settlement. We're going to call this vendor. We're going to call this credit card company. You know, here's what we're going to do if that doesn't happen.
Okay.
Because if then an income qualifying test usually takes about an hour to complete.
Okay.
And if you have not brought all of the documentation to do that and a little bit of money to pay the lawyer to complete it, they may not be able to give you any sort of guarantee as to what chapter you're going to file.
Okay. That makes sense.
Mm-hmm.
Okay. You have mentioned the role and the word trustee. I want you to tell us what is a trustee and their role in bankruptcy.
That's a great question. So
I have lots of them.
You do have such good questions. Well, the function of a trustee essentially is to represent the creditors you specified in your bankruptcy case. So they are the lawyer for the creditors.
Okay.
The Chapter 7 trustees have what we call liquidating powers, which means that they have the power to seize your assets that are not exempt from your bankruptcy estate and liquidate them. So sell them, take that money, and pay your creditors evenly with them.
Okay.
That's what liquidating powers do.
Okay.
Normally, there's a whole lot of things that you can liquidate in a Chapter 7 case, but if you're talking about a no asset case, it means that the debtor has no assets that are not allowed to be exempted by law in the bankruptcy, which means there are no assets for the trustee to administer. That's a no asset case, which means you can keep everything.
Yeah.
If the trustee states that they're going to abandon your property, that's a good thing because they're giving it back to you.
Okay.
They don't want it. The estate doesn't want it.
Okay.
It's not property of the estate. Do with it what you want.
Okay.
If the trustee needs to liquidate something, you will be well aware of that.
Okay.
They will be all over it.
Okay.
Now, a Chapter 13 trustee does not have liquidating powers. So they're not going to seize your car and take your car and go sell it and use that money to pay creditors. What they are going to do is collect payments from you.
Okay.
And so they're the bank.
Okay.
Every month when you make your plan payment, it's really a combination of car, house, and whatever unsecured debt you're supposed to be paying.
Okay.
Taxes, attorney's fees, etc. Those things are all paid in it. Child support, arrearage, that can be paid in it.
Right.
One of the things you have to attest to in order to receive a Chapter 13 discharge, you have to attest that you are current on your child support payments. It's very important.
Right, of course.
So the trustee is simply going to collect payments and disperse them.
Okay.
And they are paid a fee for that. So the Chapter 7 trustees get paid based on how many assets they can collect.
Okay.
A Chapter 13 trustee gets paid based on the amount of money they collect.
Okay.
So they have a vested interest in making your plan payment as high as possible.
Okay.
And the debtor's attorney has a vested interest in keeping your plan payment as low as possible.
Sure.
So those two things tend to have to meet in the middle somewhere.
Right. Yeah. Is there anything that cannot be discharged in bankruptcy? Because I've always heard student loans cannot be discharged in bankruptcy. So is there something, or if, say somebody has has engaged in negligence and there's a judgment against them for, a large amount, can they discharge that in bankruptcy?
Those are good questions too.
And it depends.
It does depend. There are always exceptions, but standard answers are, you're not going to get rid of your student loans.
Right.
You're not going to get rid of tax debt.
Yeah. Okay.
You're not going to get rid of child support.
Yep.
If you were drunk and got in a car and killed someone and they got a judgment against you, sorry.
You're not getting rid of that.
Not getting rid of that.
Okay.
But there are processes that have to be put in place. There are processes the creditor has to go through in order to preserve their debts too.
Sure.
You can discharge student loans if you sue the creditor in your Chapter 13 case. It's called an adversary proceeding.
Okay.
And it's basically the bankruptcy court's litigation arena.
Okay.
So you have to sue your student lender and you have to prove a hardship. The burden of proof is incredibly high. So not only do you have to prove that you cannot afford your student loans now, you have to be able to prove that you will never, ever, ever, ever be able to afford them ever in your life.
So maybe a disability.
Perhaps some of the case law that I've seen, people being successful, extreme handicaps with children involved, who also have their own problems.
Yep.
One case I read, a guy was in a vegetative state in the hospital, in coma.
Yeah.
Really, really extreme situations. I would say, people who owe a couple $100,000 and aren't making very much money, there's a possibility that you might be able to discharge them. But again, the burden of proof is really high.
Sure.
And student loan creditors, they have money and they have lawyers.
Yeah.
And they know that it's really hard to discharge student loans. So what they try to do is paper people to death.
Right.
So that usually the goal of a student loan adversary proceeding is to try to go in and renegotiate your student loans with the creditor so that we can get a settlement agreement on file. It's more affordable than any other options that you have.
Sure.
That's usually the best goal. And
Mm-hmm.
and I don't like to approach those with the idea that the goal here is to discharge all of your debt, because the likelihood it's going to happen is pretty low.
Right.
The other thing, taxes can become dischargeable if they have been filed into a knowing for more than 3 years. If there's no tax lien against you, it is possible that they have lost their priority status and they become dischargeable just like credit cards do.
Good.
There are also instances, I have a lot of people who call me who are suing somebody for fraud in state court, and lo and behold, that person files for bankruptcy.
Right.
Well, that doesn't necessarily discharge your debt.
Right.
So it's important for you to understand your options.
Yeah.
At that point, you could come see me or a bankruptcy lawyer who can file an adversary proceeding. The fraud level that you have to prove in bankruptcy court is higher than the fraud elements you have to prove in state court.
Okay.
The bankruptcy court gets to determine whether your fraud has risen to the level of non-dischargeability. So it's a high burden of proof. And one of the conversations I always have with people is that, even if you win, even if the debtor did commit fraud, even if you get your judgment, you're right, you win. You're trying now to collect against a person who is admittedly broke.
Right.
So what do you think you're going to collect?
Right.
The success stories in those situations are people who are typically in Chapter 13 cases.
Okay.
They've got a plan. They're being successful in their plan. And we can build our settlement agreement into, or our judgment or whatever it is. You can build your award amount into the plan, but you're still going to get paid last.
Yeah.
So it's going to take you a while to get paid.
Yeah. Yeah. All right. That is good. All right. So I want to ask you, what are questions that I'm missing? What is something that if somebody is contemplating bankruptcy, they're watching this video, and I haven't asked you something that I need to ask you?
The other questions I get a lot are, I don't want to include that in my bankruptcy. And that's sort of a false way to look at things.
Right.
Because everything is technically included in your bankruptcy.
Yep.
When you file for bankruptcy, you are an open book to the court.
Yep.
Your pleadings are a matter of public record. Anybody who wants a copy can go down to the courthouse and get one.
Right.
Your name is published in the paper.
Yep.
I don't know a whole lot of people who are sitting around on Sunday reading the bankruptcy notices in the back of the paper, but some people, that's a really big deal to them.
I guess so.
But when you file the case, all of your creditors have to be listed. All of your assets have to be listed. Everything is disclosed. If there's ever a question about whether you report something, you err on the side of disclosure.
Right.
These are questions you have to answer under oath at your 341 meeting.
Right.
So you can't just not list a creditor.
Yeah.
And not be held under perjury.
Yeah.
Frequently, clients will forget about a creditor or forget about something, and it's usually a pretty easy fix. You make an amendment to the paperwork. You're not going to go to jail if you forget to list that payday loan you took out 5 years ago or something like that. But all of your assets are listed in the schedules. All of your debts, all of your co-debtors, their names, their addresses, your landlord, your lease. And assets are kind of tricky because you list all of your assets on schedules A and B.
Okay.
And on the day you file your case, those assets become your bankruptcy estate.
Okay.
And there are all these disclosures that are written. They were drafted by the credit card companies when the law got redrafted back in 2005.
Okay.
So they're designed to scare people out of filing for bankruptcy.
Right.
And they tell everybody all of your assets are going to be seized.
Right.
Which is sort of true and sort of false.
Right.
Because you do file schedules A and B that list all of your assets in your bankruptcy case. But you also file a Schedule C. And the Schedule C is what sort of pulls all that stuff off the table.
Okay.
Most people have all these exemptions that they can apply to their property, and you pull all of their property out of a bankruptcy case. If at the end of the day, there's still something listed there, it's more of a let's make a deal kind of situation.
Okay.
So if you have grandma's fur coat and you've got to keep grandma's fur coat and it is super, super, super valuable and there is no exemption that applies, then make an offer.
Okay. Yeah.
So,
all right.
There's always a way out of your problem.
Yeah.
The important thing, I think, is to be aware of the problem, to be aware of it before your case is filed.
Yeah.
And to have a plan of action for how you want to approach it.
Okay.
There are very, very, very few problems in bankruptcy court that cannot be solved. What's difficult to solve is if you are intentionally withholding information from your attorney and they find out about it at the creditors meeting, then it's a much more difficult problem to solve.
Right.
If you're as forthcoming as possible and disclosing as much as you possibly can, there's very, very few problems that we can't solve in one way or another.
Yep.
Sometimes it depends. It's going to determine whether you file a 7 or a 13.
Okay.
Sometimes it's going to determine whether you keep your house or not,
Yeah.
or whether you keep that property,
Right.
or, can we sell that property, or, can you go buy another one after, 3 years from now, after the case is over and you just let this one go, or
Right.
certain things like that.
Okay.
So.
Well, obviously she knows what she's talking about. So if you want to get a hold of Betsy, her number's on the screen. It's also in the written text below the video. She is happy to answer your questions. I'm sure, do you do phone consultations?
Yes,
Okay.
I prefer phone consultations. And
Okay.
most of my clients do too. And I
Okay.
will hold them over lunch hours or in the evening
Okay.
or on a weekend, whenever you need them.
Okay. And so I hope you give her a call. She obviously has a lot of the answers. And I'm sure if she doesn't know the answer, she goes and looks it up and consults with people. So anyway, so anything else you have to add?
I think that there are a lot of problems that can be solved for people by just having the courage to pick up the phone and make that first phone call.
Oh my gosh.
I understand that it is scary.
Yes.
I understand that you are terrified. I understand that you are confused, and information is power.
Absolutely.
And you're not going to get anywhere unless you have the right information. And,
Absolutely.
a phone consultation, I offer a free 30-minute phone call. And I will be able to tell you if this is appropriate for you, if so, what chapter you're eligible to file, any problems with your case, and more often than not, I can quote you a fee.
Right. Okay, great. And I think one of the things is there's some shame associated with this. If I couldn't make this payment, or I'm, kind of under this avalanche, and there is just no shame associated with this.
No.
And especially with your lawyer is there to, be your advocate, be the help to you. And that's what she would do in this situation. There's just let go of that shame and get yourself in a situation where you do get a second chance.
I like to tell people that, more often than not, somebody's gotten sick, somebody's gotten hurt, somebody's died, somebody's lost a job.
Right.
There are all these things that happen to people that are totally beyond your control.
Right.
And you can't fix those things. But there are things we can do to fix the situation down below that's all getting affected by those things.
Absolutely.
I can't bring your spouse back.
Right.
But I can make the loss a little more bearable by cleaning this up for you.
Yes.
And so I don't want people to feel like they have failed or that they're doing something wrong by calling me, because this is a responsible way of dealing with your problems.
Right.
Like I said in the beginning, people would never think and invent and create and open businesses if these remedies weren't available. There's a reason they're here, and they're here to help the people who need them.
Yes. Preach, girl. I love it. I love it. All right. Well, thank you so much for watching. I would love for you to subscribe to the channel or subscribe to my Facebook page. And everybody have a great day. Bye.